Thanks everyone for coming to this little discussion. This is how I start off my class. Again, I teach at Wake Tech. I'm the political science professor for the southern campus of Wake Tech. Teach intro to U.S. government, state and local government, international affairs. By way of qualifications, I graduated from Campbell University while I was on active duty at Fort Bragg by taking online classes and evening classes, online classes while I was deployed, evening classes. Then I have 3 further graduate degrees in legislative affairs from George Washington University, public administration from Harvard Kennedy School of Government, and public leadership from the University of San Francisco. So I started teaching as an adjunct 3 years ago, and have been teaching full-time for the last 2 years. So that's a little bit of credibility and a little bit of background about me. But this is generally how I introduce my students when we're taking an Intro to U.S. Government course on the founding documents, the foundations of our government. Let's see if this thing will work. There you go. So our founding documents, we generally think of them as the Declaration of Independence, the Articles of Confederation, the Constitution, the Federalist Papers, and the Bill of Rights. Those are our founding documents. And I'm just going to use a drawing to demonstrate the importance of these documents. These founding documents are the foundation of our governing system, under which what we've built our society upon, these documents. These are the 5 documents that judges, lawyers, and lawmakers still refer back to when talking about how our society is structured and built upon. So it creates the foundation of our governing system. We're going to talk about these 5 founding documents, and then a caveat that you really can't talk about the Bill of Rights or the American values that we get out of these documents without talking about the second founding, which is really the Reconstruction Amendments, the 13th, 14th, 15th Amendment, and particularly the 14th Amendment. So we'll end talking about the 14th Amendment. So, the Declaration of Independence, the first of the founding documents. This was obviously created as a way of breaking away from England, from the King of England. This was, occurred following a number of conflicts, primarily in Massachusetts and Boston. You had the Boston Tea Party, the Boston Massacre, and then the shot heard around the world, the battles of Lexington and Concord, that really spurred the rest of the colonies into doing something. So in 1775, you had elements, folks from all of the colonies, from all 13 of the colonies, come together. Each of them had established legislatures of some sort, so they had delegates that came together in Philadelphia and to decide what are we going to do about this situation in Massachusetts. So you have them come together, you have a vote amongst this delegation, what becomes known as the Second Continental Congress, thank you very much. And so you have these folks come together and they make basically 3 decisions. One, they're going to immediately send George Washington and an army to form an army and march up to Boston to support the Massachusetts militia that were there actively fighting English troops at the time. Second, they're going to send an olive branch petition to the king and Parliament, essentially saying, hey, we're sorry that this conflict is happening. Let's have a conversation. We're starting with an apology, and then let's move forward. But at the same time, they said, we need to have a forceful, and there was a debate amongst the delegates. Some folks wanted just to say an apology, King, please stop attacking your own people here in the colonies. Then another group said, no, we need to be more forceful. So at the same time they sent the olive branch petition, they gathered a group of people and said, let's have a more forceful statement to the king, to Parliament. And that ends up being what we know as the Declaration of Independence. You have Benjamin Franklin and John Adams primarily tasked with writing this more forceful statement is all that they were tasked with doing. But they pulled in Thomas Jefferson, Benjamin Franklin from the state of Pennsylvania, John Adams from the important state of Massachusetts, where all the action was happening. Adams had the idea of pulling in Thomas Jefferson from the state of Virginia. Virginia being one of the most populous states, one of the most important states in connecting New England to the southern states, at least the central Atlantic states. So Thomas Jefferson is tasked with writing that first draft of the Declaration of Independence. He's influenced by Enlightenment thinkers like Rousseau, Locke, and John Calvin, and Thomas Hobbes. These are folks that were writing about natural rights and how people should be able to make their own statements against their rulers. Remember, in most of Europe, you had monarchs as the heads. You had a parliament in England, but it did not establish broad freedoms for everyone in England, hence the breaking away. So Thomas Jefferson goes off to write this letter that they want to propose to send to the King of England. Now, Adams and Franklin are shocked when Thomas Jefferson, this letter is a full-on Declaration of Independence from England. They did not expect, the initial delegates did not expect this to be the call. It was supposed to be a more forceful letter, something just to balance out the olive branch petition. But Adams and Franklin, two influential delegates at this Continental Convention, quickly got on board and saw the value and the strength of what Thomas Jefferson wrote. So they agreed, they did some editing. It had to go back to the Continental Congress. There were additional edits that happened. Thomas Jefferson didn't necessarily like all these edits that were happening, but they happened, and what we know today as the Declaration of Independence was signed on July 4th, our Independence Day of 1776. Signed and then sent off to England. And this is what we know as the Declaration of Independence. So why is this? Yes, it is important because it broke us away from England and really established the increase in force of the Revolutionary War. But that's not why lawyers and judges look back at the Declaration of Independence. It's really because the Declaration of Independence established American values. You have the famous credo in the Declaration of Independence that all men are created equal and are endowed by their Creator with certain unalienable rights, like life, property, and the pursuit of happiness. It is this American credo that is the most important part of the Declaration of Independence that we look to as a founding document. This is the beginning part, the first kind of paragraph of the Declaration of Independence. After that, it's a long list of grievances that England committed against the colonies, and less important for historians, important for historians, I shouldn't say that, less important for lawyers, judges, and in the foundation of the government. So, and of course, these are values that we continue to strive to live up to, and we'll talk more about some of them, how we strive to them when we talk about the 14th Amendment. So then they sent off the Declaration, and we end up fighting the war and miraculously win this war with the help of France. And so we ended at the Battle of Yorktown. They signed a treaty between England and the United States. Now what? Now what are these colonies now going to do? They've declared their independence, and they have to establish a new form of government. So what they do is they turn their colonies into what they call states, and then they start negotiating amongst each other. And that final negotiation, what they come together and agree upon, it becomes known as the Articles of Confederation. They land on what we now call a confederated style of government, where the state is the primary entity, the source of power, and the states join together in a confederation of states. And it has some some serious issues, but it's the first attempt at a democratic form of government. And I learned quickly that these are a little bit too weak. This is a critical, we think of the Articles of Confederation as being a part of the foundation and kind of like a critical brick in that foundation. That, again, what historians, judges, lawyers continue to look back to are largely the failures, the flaws in this form of government, in this confederated style of government. So there's a number of things, kind of 5 primary ones that we look at largely, and these are things that obviously get built into the new Constitution. You'll see why these things were so critical as we move forward. One, there was no way for the federal government, the Continental Congress, built up all these debts. There was no mechanism for the federal government, this weak federal government, to collect taxes. I should go back and say, so this confederated government was led by a confederated Congress. So one delegate from each of the states came together to make decisions on behalf of the federal government. All decisions generally had to be unanimous, so they weren't actually getting a lot done. The federal government couldn't collect any taxes, therefore they couldn't pay off any debts. So the states were paying off their debts at various degrees, but the federal government couldn't. Each individual state was printing their own money, so something that we know a lot about today. There was rapid inflation because they were competing against each other and just printing money, not based on any gold supplies, on any banking system, but just continuing to print money. And one state wanted to have more than the other, so the other state printed more, and that's how you get rapid, out of control inflation. Again, this Confederate Congress had to be unanimous. It was very hard, as we know about politics today. Hard to get unanimous, try to get everyone on the same boat to be able to make decisions together. So a lot of things simply didn't happen because they couldn't get everyone on board. One of the most important things that our federal government does today is control and regulate interstate commerce between the states. There was no way to do this in the Confederated Congress. Each individual state was acting as if they were their own country, so they would put tariffs on their adjoining states. And ultimately, the southern states were starting to form closer trading ties with England, while the northern states were forming closer trading ties with France. And this ultimately led to a difference in foreign policy and started to be a danger of this new young government being pulled into the growing and soon-to-be war between England and France. So for all these reasons, the Articles of Confederation only lasted for about 7 to 8 years, started to see cracks in the idea, in the concept pretty soon into, as they focused on these state governments, but there needed to be something stronger, a stronger federal government to help tie these states together. So one of the impetuses of rethinking this relationship between the states is an event that happened out in western Massachusetts. You have a bunch of Revolutionary War soldiers who never got paid. Most Revolutionary soldiers that fought never got paid because the federal government couldn't pay them. But they were being asked to repay their debts. They had to take out loans to get farm equipment to go back to their lives and farm. Those state creditors were going back and saying, hey, you need to pay us back for all that money you loaned. And they were saying, essentially, well, we never got paid for our Revolutionary service. We'll pay you as soon as the federal government pays us. And there was a couple dynamic leaders that came together and organized these folks to go and kind of basically ransack the creditors and fight against this young government. This became known as Shays' Rebellion. It was led by a gentleman named Robert Shays, I can't remember his first name, but a gentleman named Shays. But this gets the attention of George Washington, a number of the other delegates that had been, or prominent folks in the states, and realize that something has to give. We've got to change this form of government. So they decide initially to meet in Maryland. They can't get all of the states there. Finally, names that you'll hear over and over again, Alexander Hamilton and James Madison, convinced Washington to come to this next Congress of Delegates, and they decided to meet again in Philadelphia in 1787 to talk about how we're going to amend these Articles of Confederation and try to make this government more acceptable, more efficient, and not fail in this new country. So you end up having 55 delegates that come to Philadelphia and meet in the Philadelphia State House. They decide this is the summer of 1787. They decide to meet in secret. They close all the doors and promise each other that they're going to have an honest debate and not talk to the press or talk to outsiders about what they're negotiating, so they can come to some honest compromises and negotiations throughout this process. And they pretty quickly decide that the Articles of Confederation is failing and we need to move on to something completely new. And this is what they do. So again, last 3 months in the summer, they quickly identify that they need a new and novel structure under which our society needs to operate and our citizens can live under. And so they start to hash out what that could be and what that should be. So there's really 3 issues that they really had to address in order to get down to the nitty-gritty of starting to talk about structure. They had to figure out the conflict between the small states and the large states. You have large states like New York, Virginia, Massachusetts was a populous state, and they controlled a lot of power. Pennsylvania would be in there with the large states. Then you had smaller states like New Jersey, Connecticut, Rhode Island. Even the southern states had smaller populations, so they kind of sided with the small states when it came to this conflict between the large and the small states. We had to deal with the major issue of slavery. The southern states were dependent on this practice of slavery. And so if we were going to have a union of states, they had to come up with some way to get both northern industrial states to come together with southern agricultural based states that were dependent on the practice of slavery. And then third, we had to figure out how we're going to create a stronger federal government, but how strong is this federal government going to be? And how are we going to keep it from becoming a monarchy? How are we going to keep it from becoming too powerful? What are those things that we're going to be able to put into place to spread out power and make things shared amongst the states, amongst the federal government, and how to keep the federal government in check? So let's talk about that first one. Each one of these conflicts is resolved through a compromise. We call this first compromise the Great Compromise because we have 2 plans that are really put forward. One from New Jersey, which is a small state, that says, hey, the Confederated Congress was, you only had 1 person from each state. That was definitely a problem. We need to have some other branches, but let's still have just 2 representatives from each state. Maybe let's add an executive branch of some sort to help us bring this federal government together. So you have the New Jersey plan that's calling for what we know as equal representation amongst the states. Each state gets 2 representatives. And then you have James Madison bringing forward a Virginia plan. Virginia has a very large population. They think that it would be unfair for each of the states to have 2 representatives because they have way more people. Shouldn't each individual person have representation, have equal representation in this new legislature? So they put forward a plan for proportional representation, meaning that based on your population, we'll say how many representatives you get in this new Congress. And then you have Roger Sherman, a gentleman from Connecticut, comes up with the Connecticut Compromise, or the Great Compromise, which is combining these 2 plans. the New Jersey plan and the Virginia plan into one Congress, and this gives us the bicameral Congress that we ended up with a Senate that represents the states, where each state gets 2 representatives, equal representation amongst the states, and then a House of Representatives that has proportional representation. So the more people you have in your state, the more power, the more representatives you're going to have in this new Congress. And that's what we ended up with. The U.S. House of Representatives today has proportional representation. The more people you have in the state, the more representatives you have, and a Senate where every state is equally represented in the Congress. Now, that second major conflict, what we often know as kind of the original sin of the United States, is slavery. And the compromise that they came to has had long enduring problems in our country. The southern states wanted those enslaved people to count for population. And we're talking about the House of Representatives. For that proportional representation, they would be considered small states if you're just talking about their white population, but if you added in all the enslaved people, then they would have significantly more power in the House of Representatives. So they wanted all those folks to count. But the northern states obviously said, well, you're not going to be representing these people in the Congress, so why should you get a bonus, essentially, for having enslaved people? You would be getting more representatives to represent the white people. Those representatives in the Congress were not going to be representing the enslaved people. You would just have more representatives. Each white person in the South would have more power, more representation because they used the practice of slavery. But at the same time, the southern states threatened to leave if they did not get some sort of representation for the enslaved population. And the danger in that would be obviously not having a separate country. If the country were to split at that time to a northern union of states and a southern group of states, that are 2 separate countries, you'd have a hostile country to your south and not have the huge advantage of having the Atlantic Ocean between any other major powers. And they were already, the North and South were already on 2 different sides of a conflict between England and France. So they saw it as essential to come up with some sort of compromise. And the compromise is what we know now as the 3/5 compromise, where every enslaved person in the South would be counted as 3/5 of a person for the purpose of representation. Now, this is only one of 3 mentions of slavery in the Constitution. You have the 3/5 compromise. Of course, they didn't want to mention the term slavery is nowhere in the Constitution. They obviously knew that would be a stain on this Constitution, which of course it is. But you have the 3/5 compromise. They said the Southerners also demanded that the practice of slavery would not be banned for at least 20 years. It was really the trade. Bringing new slaves into the United States would not be banned for at least 20 years. And there was a fugitive slave provision in the Constitution that states must return escaped slaves to their owners. So there's those 3 references in the Constitution, which of course have long-term implications and was that original sin of the United States. And then the next major conflict that had to be addressed is, how are we going to provide for a stronger federal government? Provide for a strong enough federal government, but if it is going to be a strong federal government, how are we going to keep it in check? And this is when we came up with the new concept of federalism. So the first attempt at a form of government was a confederated style of government. Now, in the new Constitution, they're forming a federal style of government, meaning that the states and the federal government both share power. They both derive their power directly from the people, but one is not more important or more powerful than the other, in theory. even though the federal government is supreme to the states, they both derive their power from the people, as opposed to the federal government creating the states or the states creating the federal government. They're created at the same time through this new constitution. And they're going to have separation of powers, both in the state governments that already existed, and they get this idea from the states, really, because most of the states are already split up into three branches, into an executive branch, a legislative branch, and a judicial branch. So they borrow this from the states and say that this new federal government is also going to have three separate, equal branches that are going to be dependent upon each other. So we're going to have a legislative branch that writes the rules, an executive branch that carries out the orders of the legislature, and then a judicial branch that enforces the rule of law. And this is the federal style of government that we move forward with. Now they start talking about the structure, the physical structure. What are these three branches of government really going to do? How are they going to be separate from each other? We talk about the Constitution starts with a preamble, and we'll get to that at the end, but then goes into the first three articles. Article 1 is the legislative branch, talks about the Congress. Article 2, the executive branch, establishes this office of the presidency, and this is where most of the federal government that we know of today exists. And then Article 3, the judiciary branch. I'll treat you guys a little bit as a class, because this is where I usually start asking questions of my students. Which branch of the government do you think the founders thought was going to be the most important?
The executive.
The executive?
I would say
The executive, yeah, the presidency, right?
Yes.
Yeah.
I'd say the legislative.
Legislative? Yeah, yeah. Wow.
I'm sorry, was I supposed to raise my hand?
Yeah, that's fine. Yeah, that's fine. Yeah. It's more orderly, but no, not required. You guys have beyond your student years.
Yeah, we was in school, I thought, oh yeah.
Yeah, exactly. So yeah, you normally think the executive branch, because the president is the kind of, we think of as the leader of the country. But if they were writing a constitution where the executive was going to be the most important, don't you think they would have started with the executive branch? But they didn't. They chose to start with the legislative branch. They were, again, afraid of that executive power. They were leaving a monarchy, were afraid of that massive amount of executive power. So they really believed that the legislative branch was going to be where all the action happened, where all the power was going to be and remain. And that obviously changed over time. But they put the legislative branch first on purpose. They also spent the most time describing what the legislative branch would do. Article 1 of the Constitution has 10 sections. Article 2 has 6 sections, and Article 3 has 5 sections. So they spent almost twice as much time describing what the legislature would do. And that's another reason that we look back and say that the legislature was clearly the most important branch to the founders or the framers. So briefly, Article 1 of the Constitution lays out some of what the Congress will be and what it can do. It has this great compromise enshrined in it that we will have a bicameral Congress of a House and a Senate, that the Congress, the legislature, is going to make the laws of the land through a process that is established in the Constitution of both the House and the Senate having to agree on legislation and then sending it off to the executive to be a check on the legislature. The House actually controls the budget. All budgets originate in the House because that's closest to the people. Those are the people that are directly elected by the people. The original Senate, until the 17th Amendment, are elected by the states, not by the people. The Congress also, particularly in the Senate, has an important duty, important check on the executive in that they have to ratify any treaties, ratify judicial appointments, and ratify presidential appointments. Another check, another way that the legislative branch is a check on the executive branch. And you'll see that in each of the branches. There's ways that the executive is a check on the legislature, the legislative is a check on the executive, and the judiciary, and vice versa. This is a part of that checks and balances system that federalism puts into place. So that's Article 1 of the Constitution, very brief overview of Article 1 of the Constitution. Article 2 is the executive branch, which really focuses on the presidency, establishing what this presidency is going to be. The president is going to lead this federal government, which they don't really talk a whole lot about what that federal government will really be. They leave a lot of that up to who they know, who they're pretty sure is going to be this first chief executive in George Washington. So they put a lot of confidence in George Washington being able to work out all the differences, all the things that this executive branch will be doing. It says that the president is going to be the commander-in-chief of the armed forces, which is another check and balance between the legislative and the executive. The legislature has to declare war, but the executive is the head of the military. So you have, again, these dependencies on them. The executive, one of the main problems with the Articles of Confederation was that there was no coordinated foreign policy. So they clearly put the foreign policy into the executive branch, so you have one person that's making decisions on foreign policy, not a bunch of governors each deliberating over foreign policy, or a bunch of legislators making foreign policy decisions. You have it all in the hands of one person. And it also says that the president has kind of very broad pardon authority, which was, again, because of the experience of colonists during the English, under English rule. And then it also establishes what we know as the bureaucracy. This is most of the federal government that you think of today, that exists within the cabinet departments and sub-cabinet departments. The Constitution really just says that George Washington may appoint advisors to help him carry out his duties. It's George Washington decides to make those cabinet heads, department heads, important people that he meets with on a regular basis. He establishes the first 4 cabinet departments, and the bureaucracy grows from there. And then the judicial branch, where they talked about the least in the Constitution. Again, just really primarily focuses on the Supreme Court and leaves the rest of the creation of the federal judiciary up to both the Supreme Court and the Congress later on. Put some broad duties onto the Supreme Court that it will decide legal disputes that have to do with the Constitution or disputes between the states. And it also said that the Supreme Court could declare laws unconstitutional, even though the judiciary has to kind of take that right back in one of the first big cases, Marbury versus Madison, in the 1800s. And of course, that there will be a federal court system that will help enforce federal laws. Ultimately, the Constitution is signed in September 17th, 1787, what we now know as Constitution Day. It's not really celebrated, but constitutional people that pay attention to government and Constitution always try to make it a thing, but never really caught on. But you had 38 delegates of the 55 that started out in Philadelphia. 38 of them made it all the way to the end and ended up signing this Constitution once they had debated it and got it all on paper. There were 3 dissenters, 3 folks that made it all the way to the end, that said that this Constitution is not good enough, largely focused on needing I think one of them was concerned about the federal government being too strong, and 2 of them were really focused on there not being a Declaration of Rights in this original Constitution. Whereas most of the states had these kind of opening their state constitutions. So one of the brilliant parts of this Constitution is Article 7 of the Constitution, which says how this Constitution will become the law of the land. It's a process for ratification. It's got to go out to the states, and all of the states, or a majority of the states, 9 of the 13 states, have to agree through a convention of citizens, and then a popular vote to accept or reject this Constitution. And so these delegates head off, they agree, they sign the Constitution, and head off to their states to start making the case for this new Constitution. What people are seeing as the copies are made and sent out to the states Of course, they see the structure of the Constitution, this Article 1, Article 2, Article 3, the legislative branch, executive branch, judiciary branch. But how it starts is what's called the preamble of the Constitution. It starts with the famous words that we know, "We the people of the United States," and then goes on to say, "Do ordain and establish this Constitution for the United States of America." How did these 38 white men in Philadelphia have the audacity to say, "We the people do ordain this Constitution," right? It's just like 38 representatives, mostly rich guys, but they're saying, "We the people do ordain this Constitution." What gives them the right?
Landowners.
Yeah, mostly landowners, almost all of them landowners, true. And most of the people that eventually voted were largely landowners, at least in the southern and mid states. But what gave them authority?
Well, they funded the war and they, instead of going towards thirds, I guess they felt empowered.
Yeah, well, they certainly felt, did feel empowered. That's what brought them together to write this Constitution.
Weren't they voted on and sent there to represent?
They weren't, yeah. So they were chosen by their governors or their state legislatures. So they had no, they weren't voted in, which is part of the reason that they added in this process.
Weren't they taking it from the Iroquois nation at the time?
There were certainly some ideas that had come from they largely came from the state constitutions, but I'm sure there were some ideas that had come from the Iroquois nation, particularly the concept of democracy.
Because the white men thought they were the only ones that
Yeah,
would be here.
they were white men. Yeah, they're white men.
There was some of that. There's certainly some of that audacity, but they knew this, so they did something to allow that it not be just them that ordained this
Well, the
Constitution.
French Revolution.
Based on the premise that it was formed in the Magna Carta, that they want to use that model.
So there's ideas from American democracy that comes from the Magna Carta, which is essentially the English Constitution. They don't have a written Constitution like we do.
Was it the Enlightenment?
So those are the ideas.
Yeah.
I'll give one more before I give the answer.
I've just seen the main thing about the government. The Founding Fathers understood from the beginning, because of European history and world history, that no Confederate form of government in history has ever worked.
Right.
We had them in an evil time.
Yep.
It didn't work. Even back then, the economic structure didn't exist. You could not build an infrastructure anywhere.
Yeah.
That's
Yeah.
why great empires had strong centralized government.
Exactly. And they wanted this one not to fall like all the ones previously. And so, but this is really why they had that Article 7 in the Constitution, why that Article 7 is so brilliant. Because it was not them that made this Constitution, it was the people of the states. This Constitution did not become the law of the land until a supermajority of the states had popular elections to accept this as their new rule of law. So that's where we the people of the Constitution comes from. It's because thousands, tens of thousands of people all throughout the colonies had voted for this to become the new law of the land. It was not those 38 individuals. They knew that they didn't have the authority to put down this new law. That would just be another form of authoritarianism, of them saying, you people are now going to live under this this Constitution.
But
There
it
were
was
popular
still only
votes.
white men.
It was absolutely very flawed in that it was still white men, largely landowners. It was still the elites of this society that accepted this Constitution, accepted to live under this Constitution, and then expected everyone else to live under this new Constitution. So that's where we get we the people of the preamble. The rest of it is that introduction, is that why. Why are we creating this new Constitution? And this is where we get in order to form a more perfect union, because the Articles of Confederation was an imperfect union. People often misrepresent this as thinking that the framers thought that they were creating a perfect form of government. That's not what they meant at all. The Articles of Confederation was a loose union of states. They wanted a stronger or a more perfect union of states. So that's what they mean by the more perfect union. Establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty for ourselves and our posterity. This is the why that they're forming this form of government. And send that off to the states. This was originally what they thought would help convince people and the elites ultimately in the states to accept this Constitution. But that wasn't going to be enough. Just this preamble, just this one paragraph. So we needed some more heft. And some of our framers that we hear about often came together to start making the argument, making the case for this new Constitution. There's Alexander Hamilton, James Madison, and John Jay, who ends up becoming our first Supreme Court Chief Justice. So they decide to start writing articles in various newspapers, making the case for this new Constitution, giving the context for how did we come up with these decisions, what were we thinking in this Constitutional Convention, and what made us decide to have the three branches of government, what made us decide to give the executive this much power, or the judiciary this limited power. So they ended up writing 85 essays that were sent out to newspapers, and then they were serialized, reprinted in other newspapers, and then ultimately all printed together and bound as a book and sold. This is one of the first bestsellers, or really the second after Thomas Paine's Common Sense. Bestseller in the United States was the Federalist Papers. And so these become the argument for the Constitution, and are still to this day importantly referenced by judges and lawyers to provide the context behind the Constitution. So that's why it's considered a founding, we call it a founding document, but it's really 85, it's really a whole book, 85 individual essays that each have an important topic. In my class, I'll talk, about Federalist 10, Federalist 51, Federalist 78 for their various things. We won't go into any more depth here, but it is providing that why of the structure of the Congress. So now we have the founding documents as our foundation for our governing structure, but now we have this Constitution, which really provides the structure of our new government. And then you have the three branches providing the pillars that hold up that structure. You have the legislative branch, executive, and the judiciary branch. The founding documents provide the foundation of this home under which our society lives. The Constitution provides the walls, the structure, and the three branches really hold up that house. This is the house under which our society is meant to live, survive, and thrive underneath. But there's something that was missing. When they left or when they were finalizing debate on the Constitution, some of the delegates, particularly a couple of those dissenters that decided not to sign the Constitution, said that something was missing. Many of our state governments have a Declaration of Rights that lay out specific rights that folks have. A debate ensued because some folks, Madison in particular, was nervous that if we start writing out rights, we're inevitably going to forget some or miss some. So someone's going to assume that just because we didn't list it out means that right doesn't exist. So there's a danger in starting to list out the rights. And a hot debate started. This was towards the end of the convention. It's a hot summer in Philadelphia. They ultimately end the convention and sign the Constitution with the agreement, with the tacit agreement, that the first thing that this Congress does is going to be come back and debate a list of rights that need to be included, and these are going to be used for the Article 5 of the Constitution, lays out the amendment process. This Constitution was always meant to be a living document that can be amended, and they wanted to test out that amendment process, where you can make, the House or the Senate can make changes to the Constitution, but then those changes have to be ratified by the states. So they first asked the states to sign this Constitution as is, and then said the first thing that we're going to do is make amendments to that Constitution after this first Congress, after we've elected the first batch of representatives to the first constitutional Congress, which ends up happening in 1789. So in 1789, you have the delegates come together and start debating how this new government is going to operate, and you have James Madison coming up with the first 12 amendments to the Constitution, and they vote on these, they debate them, and shape them. They're mostly, when they sent the Constitution out to the states to be ratified, they also asked those states to tell us what is missing. What do you think should be added to this Constitution? So a lot of these first amendments came from those recommendations from the states, as well as things that are listed in the individual state constitutions. Many of them, particularly Virginia and Massachusetts, started with, and North Carolina's as well, were opened with a Declaration of Rights. So of those 12 amendments that were passed in the House and the Senate, that were sent out to the states to be ratified, 10 of those 12 were ratified. 2 of them were not ratified by the states, and therefore did not become incorporated into the Constitution. And those first 10 amendments are what we call the Bill of Rights. So these first rights, established rights in the Constitution. And we think of that as the roof of this house, the protection that protects this house. The Bill of Rights. So we know many of these. We don't have time to go through each of them individually, but you have the 10, of course, the First Amendment, freedom of speech, press, religion, as well as assembly and petition. This is also, most people, when I ask my students, what do you think is the most important amendment to the Constitution? What do you think most of them say? A lot of them do say the second one. That is true. A lot of them say the first. Why do you think most of them say it's the First Amendment? Because it's the first, right? Yeah, just the same way that we talk about the legislature being most important, because it's the first. It actually wasn't the first to be proposed or the first to pass. The 2 that were not ratified by the states were actually meant to be the first and the Second Amendment, but they were not ratified by the states. One had to do with congressional pay, that basically said that Congress can't raise its own pay. You can only raise pay for the next Congress. So you can raise pay for the next guys. And so the states, for some reason, didn't like that one. Yeah, and then it ended, ultimately, the coolest story about these is that it ended up becoming the 27th Amendment. From a college kid that did a paper on the amendment that didn't pass. He got a C on the paper and thought that was thought it was better than a C paper, so he started writing letters to state legislatures and ended up getting it passed to become the next, the latest change to the Constitution.
What
Yeah.
state brought you on this list? Is it North Carolina?
That brought on this, all the states ratified.
Yeah, but there was one main one that added, you needed to add state rights.
I mean, Virginia had the Virginia Declaration of Rights, so they're all states contributed to what ultimately became the Bill of Rights,
And Dan agreed to it.
and then ratified them as well. Yeah, eventually. So you needed 9 out of 13 states to ratify each of the amendments. Ultimately, they all did, but it took some time.
What was the second of the 2 that didn't get?
Was district size. James Madison was adamant about districts being small enough that you could actually visit them on horseback. So saying that congressional districts should be no more than like 30,000 people.
Wow.
And the states, didn't agree with that. It would be limiting. They'd have to change it eventually because there was a firm number.
They want to do all the gerrymandering.
Right. Well, yeah. They didn't realize that was going to be a thing yet, but they quickly did. But yeah. So those are the 2 that didn't get ratified. So the first, it's actually in order of where they amend the Constitution. Freedom of speech, press, and religion would amend Article 1 of the Constitution. The right to bear arms would be someplace later in Section 5, I think, of Article 1. So it's where the language would be inserted into the Constitution. So it's not in order of importance. So the first and second are not there because they're the first and second most important.
Yeah.
It's just because of the order where they would be inserted.
Well, so many of them have to do with being arrested.
Oh yeah, so why do you think that was?
Because of what happened before with the being taken prisoner when during the war.
Experiences in the Revolutionary War?
Yeah.
Same thing, yeah, exactly. It was because of the abuses of the English king and officials. So you have Article 1, 2, which we all know lots about. Article 3, or the third Bill of Rights, Third Amendment, doesn't really apply much anymore. We don't have to worry about troops coming into our homes. 4 through 8 all have to do with our criminal justice system. Really establish the rules of our courts. Protections against unreasonable searches and seizures in the Fourth Amendment. Really, this is the closest thing we have to privacy, even though we don't have a constitutional right to privacy in the United States. Other countries do have stronger rights to privacy, but we do not. The Fifth Amendment, I have there just the right to due process. But it's actually, if you ask constitutional scholars what's the most important amendment to the Constitution, it would be the 5th and the 14th Amendment being the most important. If you ask them what was the most important in the Bill of Rights, it would clearly be the 5th Amendment. This establishes due process, just that there will be a process for accusing someone of a crime. They can appeal that crime, and the government will not abuse that. It establishes that you can't be, what most people know the Fifth Amendment for is the self-incrimination. I plead the Fifth. It does say that you don't have to self-incriminate yourself, but that's actually a fairly small part of the Fifth Amendment. The Sixth Amendment really establishes what our current court systems look like. It says that if you have a witness, be a witness against you, you can bring your own witness. They have to testify to your face. That's why the witness is next to the judge facing the jurors, that we will have a jury, that we will have a right to a jury. The Seventh Amendment really is focused on civil trials, that you also have civil trials, a jury in civil trials, federal civil trials. And then the 10th Amendment, the 9th and 10th Amendment are the ones that are the least talked about. The 9th Amendment really says that that's the one that was there for those folks that were worried that if we start listing amendments, we're going to inevitably forget some. So the 9th Amendment basically just says that just because we haven't listed it right out here does not mean it doesn't exist. And any rights that we've left out still are retained by the people. If we don't say it explicitly in the Constitution, then that right is retained by the people.
Does that ever?
How often has that ever been used?
Has it ever been used in any case?
Never been used in any, what we say an amendment has been strengthened or weakened or uses in majority opinions by the Supreme Court. So the Supreme Court uses amendments and parts of the Constitution to justify their decisions. No majority opinion has ever used the 9th Amendment as a justification. So that's something that could happen in the future. It doesn't have much power or weight because of that, because it's never been used in a majority opinion. But there is some possibility there.
Excuse me.
Yeah.
Why did you just go over the 8th Amendment, and why do we ignore it?
Yeah, well, that's a very good question. I didn't mean to skip over it. It's incredibly important that we have no cruel and unusual punishment, that the Constitution says that we will not use cruel and unusual punishment in the United States, but that is, what is that defined as?
Excess bail.
And then the other piece is excess bail, that we will not have excess bail. And that is incredibly controversial today, because we have an entire system of cash bail built around our county courthouses. You see the billboards around county courthouses. Many people believe that we absolutely do have excess bail in the United States.
It's a living constitution, so 4 through 8 get defined depending on who's in power.
Yeah, no, absolutely, and that's an ongoing debate that you're very right to point out, because that's something that we have to constantly point out to ensure that people recognize and know that this is something that needs to be continued to be debated. Because yes, there are many people that believe that the cash bail system that you have to pay to get out of jail in many instances is a
Like
violation of the Eighth Amendment
Yeah,
to
because
the
they try to get
Constitution.
away from debt or prison,
Right.
yeah.
Yeah, and and all of the organizations that are fighting against us use the Eighth Amendment as their justification, saying that these are clearly in their case violations of the Eighth Amendment. And then the 10th Amendment basically says that anything enumerated in the Constitution, if it's not listed as a power of the federal government, is a power of state governments. Yeah.
The Hooper law that they're putting, Harper law that they're putting forward now, what's the effect of that law on the Bills of Rights we just saw from the Constitution?
I don't know the.
They're making a law that's going to put the legislature of each state.
Oh, Harper v. More.
Right.
Yeah. The independent state legislature theory. That's probably doesn't really address anything in the Bill of Rights directly, but this Harper v. More. I think we had a whole session on Harper v. More, but it ultimately is trying to say that the state legislature has sole authority to redistrict. To do the process of redistricting, and that there should be no oversight by the courts. There's no precedent for that being the case. The courts have oversight over everything else that the legislature does, but it does say in the Constitution that legislatures have the right to redraw districts. It doesn't say states, which is where it usually references what states can do, what power states can have, but it specifically says
I
legislatures.
think the Constitution does say that you can't gerrymander, if I remember.
It does not. Yeah, it gives sole authority to the legislature, and that's the problem. Is
Say the
that
North Carolina Constitution
I
says?
know,
no, the U.S. Constitution? Either Constitution, North Carolina or the U.S. Constitution, don't say anything about gerrymandering because they didn't imagine it at the time, and so it has come up since in the years since. But yeah, that's going to be a case that the whole country is going to be watching because it unfortunately doesn't really apply. Not as important to us anymore because the Republicans have the state legislature. Have the Supreme Court.
It seems to me that if the Supreme Court decides that the legislature cannot be overseen by the Supreme Court, then aren't they saying that the Supreme Court cannot oversee Congress?
No. Yeah. It'd be a totally separate thing because it's specifically about gerrymandering, specifically about this one case. So the last thing I wanted to talk about is obviously what's missing. So we talked about the Constitution, the Bill of Rights, establishing these rights in the Constitution. What's still missing? We talked about the Declaration being the establishment of our values. What was that original credo? All men are created equal, endowed by their Creator with certain unalienable rights.
Yes, and no women.
Well,
Yeah.
the Constitution never says a word, female or male,
That's true.
in the Constitution
Yeah.
until you get to the 1800s.
Yep, and largely we talk about the Declaration being something that we're living up to, and we say now that the Declaration meant that all men and women were created equal, which is hopefully what most of us believe. But there was a large group of people that were purposely left out. Yes, women, of course, and not to disregard that by any means. But there was another large group of people that were obviously not included when we said that.
Enslaved people.
The indigenous people?
Indigenous people, absolutely. So there's two groups of people, I should say. Indigenous people and those enslaved people at that time.
So in other words, everybody except white men.
Right, yeah.
And they usually had their own land, right?
So that was left up to the states
Yeah.
on who could vote, who could participate. That was largely left up to the states. But so when we talk about the founding documents, generally it's the Declaration of Independence, the Articles, the Constitution, the Federalist Papers, the Bill of Rights, but then we have what we talk about as the second founding, when we actually started to live up to the values in the Declaration of Independence. And that obviously didn't happen until the Civil War. I don't know if I can get volume here. No, we'll skip over this. But if you haven't read or seen What to the Slave is the 4th of July, it's a very famous speech by Frederick Douglass. Makes the point of, you have this 4th of July, that's why we have Juneteenth now as a federal holiday, is that the 4th of July does not apply to the enslaved person or the African Americans even right after the Civil War. So we call the Reconstruction Amendments the second founding, when we actually started to live up to those values. Really, in particular, the 14th Amendment. This is where we extend those rights, we enshrine those values of the Declaration into the Constitution, and then we extend, the original Bill of Rights only applied to the federal government, it didn't apply to the states. And then obviously the Civil War showed us that that was going to be a problem, and we had to force states to live up to these values as well, because they weren't providing those justice rights to enslaved people or former enslaved people. So the 14th Amendment is what we largely think of as the second founding. The 4th Amendment really extends the 5th Amendment, what we talk about as being the most important of the Bill of Rights, extending that 5th Amendment to the states, saying that all people, the 5th Amendment says all citizens must be afforded due process. The 14th Amendment says that all people must be afforded due process. So all people within the United States must be afforded due process, citizenship or not, and this is really meant to apply to the formerly enslaved folks, and most importantly. And then the process of the Bill of Rights being incorporated to the states having to apply to them took time. It didn't happen immediately in the 14th Amendment, but it mostly took place with the 14th Amendment. But there's 4 incredibly important clauses to the 14th Amendment. You have the Citizenship Clause, basically establishing birthright citizenship. If you're born in the United States, then you are a citizen of the United States. The Due Process Clause, and again, extending that due process to all persons in the United States. Equal Protection Clause, this really codifies that promise in the Declaration of Independence, that all people will be afforded equal protections under the law. And then the Privileges and Immunities Clause begins that process of incorporation to the states.
And it's pretty, it's huge.
Yeah, the 14th Amendment. So if you ask most constitutional scholars, what's the most important amendment to the Constitution? It's the 14th Amendment. That's what all of our civil rights fights and Supreme Court cases are largely based on the 14th Amendment and trying to live up to the promise of that 14th Amendment. Of course, we know that the southern states just continued to ignore the 13th, 14th, and 15th Amendments for another 100 years, what we know as the Jim Crow era, all the way until the Civil Rights Movement. Yeah. So yeah, that's my overview of the founding documents. Hopefully this is a little Civics 101 to refresh your memory. You probably learned most of this stuff in school sometime in the past, but it's always good to get a refresher. And yeah, thank you guys for listening.